gentlemen, welcome back to the Security Expo podcast, and we are here on the show floor with Alex Karazik from Duane Morris LLP, and I am your host, John Bigelow from Security Solutions Media. Alex, welcome to Australia and welcome to the podcast.
Thank you, John. Grateful to be here. I appreciate the warm welcome to Australia and to the podcast.
You've had a long trip all the way out from Chicago. It's about, a 14-hour flight from LA and another 6 from LA to Chicago.
Yeah, 14 and 4. So it was no shortage of air miles racked up, but I am so glad I came. Tremendous opportunity to see a different part of the world and collaborate with some of the greatest leaders in the security space.
And your presentation was on dealing with class actions in data breaches. And we've spoken a little bit about this on a previous podcast, but obviously that was before you'd had the chance to give the presentation. So we didn't want to give away too many of the details. But now that the cat's out of the bag and you've given the presentation, let's sort of dive in. So give us an overview of the presentation and what were the main things that you were sort of covering?
Sure. So at the outset of the presentation, John, we discussed the global landscape for laws regulating data and data security. In the United States, all 50 states have unique provisions. You've got HIPAA, which protects medical information. In Europe, you've got the GDPR. In Australia, you got the Privacy Act of 1988. Asia, each country, it seems like, has its own either commission or regulatory body or statute. So the purpose of starting there is to set the framework that we're dealing with an international patchwork of laws. Many of them are similar. Many of them impose a duty on companies to protect data, to protect personal information and the like. But they're nuanced. So for multinational companies or even companies in the U.S. that operate in different states, you've got to be mindful that you're complying with all these and not end up in that compliance minefield. And then from there, we pivoted into some of the nuts and bolts of the data regarding the data breaches in the USA. As we mentioned in our last podcast in 2023, there's $515 million in the top 10 settlements back in last year. And we talked into some of those and what those numbers were. The T-Mobile case was leading the way at $350 million. We talked about a few of the other types of industries that were involved, and then talked about some of the data breach class action filings.
Okay. Now, you mentioned we were having a discussion before we jumped online to record this, that the number of class actions that you're seeing in the US is growing exponentially year on year. Walk me through that, because what sort of growth are we seeing?
Yeah, so in 2021, there was approximately 600 data breach class actions filed, and 300. And then in 2022, that number doubled to 600. And then 2023, it doubled again to 1,300.
Wow.
And when we check back with me at the end of this year, hold me to it, but my bet is that it's going to be over 2,000. Now, it might not make it there this year, but if not this year, I think next year. And I think there's a lot of reasons for this, right? First of all, we look back a few years towards the pandemic. Since then, a lot of companies went remote. A lot of workers went remote. A lot of companies have also gone to cloud storage systems. We've increasingly become dependent on a digital society, and that's not necessarily because of the pandemic, but I think that the last few years has accelerated that process. And at the same time, the bad actors, the hackers, have gotten really good. So what you're seeing here now is more breaches, more publicity for these breaches, which is catching the eye of the plaintiffs' bar and the government regulatory bodies. And from there, you're seeing more class actions get filed.
Okay. But it seems that we're in an environment now where, from a cybersecurity point of view, it's not a case of if, but when. At some point in time, almost any organization runs the risk that they're going to suffer a breach. And obviously, in that breach, we've had a number of them here in Australia, and they're on public record, so we're not letting any secrets out. But, things like Medisure, Optus, Medicare, not Medicare, Medibank, there was another one recently, another financial institution, but there's been a range of them. I guess my point is, how do we protect against these class actions? Because there's only so much that you can do. And it's that old, Donald Rumsfeld sort of, quote back in the early 2000s where he's like, the terrorists only have to get it right once. We've got to get it right every single time. It's the same in cybersecurity. We've got to get it right every time. The hackers only need to get it right once. How can we protect against class actions like these?
It's a great question, John, and I think it starts with doing things like coming to the ASIAL conference today. It starts with collaborating and talking amongst different people. Some of the questions I got today at the presentation involved, how do we get organizations to invest in data security measures? And I thought my answer was, I think the right arm's not always talking to the left. And one of my suggestions or takeaways from my presentation is we need to create task force. We need a CIO on the task force, IT folks, people on the ground with the technology. We need legal. We need HR. Maybe someone from business to evaluate the costs. We need outside expert consultants, people that are data security experts that may be outside the organization. They can come in and do assessments of organizations with an open mind. Assessments are important, right? Because how are you going to get better if you don't identify your weak spots? But I think creating these types of task force or committees, both in the outset of the formation of an organization, or even if your company's a long-standing organization, it's never too late. Figuring out what are your weak spots. I think another thing that's important too, not just prevention, is having mitigation plans. What if you get breached? What are you going to do about it? Who's going to be the voice of the breach? What steps are you going to take? It shouldn't just be, I'm going to call Alex or I'm going to call a lawyer at Duane Morris or another law firm and hope they figure it out. But companies should, and by the way, businesses should do that too, of course. But they, and get legal involved. But they also need to have an internal plan for what are we going to do right away if this happens? How are we going to stop it? How are we going to plug the leak, so to speak?
Yeah. Well, it seems there's two parts to that. If we go back to your initial thought around task forces, it seems to me that cybersecurity has forever and a day suffered from this affliction of if they do their job well, then nothing happens and the board starts to question, why are we paying so much for cybersecurity? But what we are getting out of a lot of these class actions and data breaches that we're seeing now is data on what happens as a result of these breaches. And we know from an ICT point of view, we can track metrics around attempts, what sorts of data they were trying to access, what data breaches were thwarted and all that sort of stuff. To your point, if you had a task force that was able to front up in front of the board and say, in this quarter, we tracked X number of attempts. These were the kinds of attempts. This is what they were after. Had they been successful, based on what we've seen in class actions over the last couple of years, this is what it could have potentially cost our organization. And next time they might be, so we need X amount to stop that from happening. Surely that's the kind of thing that they need to be doing to justify their existence.
Absolutely, John. And to go back to your first comment that you said the board looks at a cybersecurity task force and wonders, well, what are we doing if they're not hearing from you? It's kind of like a referee in sports. If the referee's not talked about on the post-game show and no one mentions them and they do their job right, they're not going to get any credit for it. That's just what their job is, right? And it's often not necessarily a glamorous or, glorified task force because, if you're preventing these types of breaches, you're preventing these hacks, you're implementing these measures, you may be spending time and money, not just money associated with prevention mechanisms like ransomware or software that prevents ransomware or trainings that prevent phishing attacks, but it's also the time of the human capital, right? You're expending man hours doing this. You're taking employees away if you should be doing your trainings regularly. You're making them do a couple hours of training each year. So essentially, they're like, all this is costing. But when you're armed with that data, like some of the figures I showed in my presentation, the last year, the top data breach was a $350 million settlement. This year, in 2024, Google also has a $350 million settlement that's on the books. So if the top two settlements the last 2 years total $700 million US, which is near $1 billion in Australian currency, that's a lot of money. And I think that the board should be looking at those figures and thinking from a cost-benefit analysis, do we really want to maybe risk not spending a little bit to save potentially a lot down the line?
Yeah, the money, as ridiculous as this comment may sound, though, on the surface of it, the money's kind of not really the relevant factor, is it? Because it's the trust that's lost out of these data breaches. I mean, the reputational impact on these organizations probably translates into, in the case of Google, way more than $350 million. Are you seeing that in what you're doing?
Absolutely, and that's a great point. You're dealing with trust both from an employee and a consumer perspective. If your company gets breached, you don't want your employees showing up to the office every day wondering, are they really guarding my driver's license? Are they guarding my Social Security? Are they taking measures to protect it? I saw that their customer information got breached and vice versa. If you're a consumer, one of the top breaches from last year involved a petrol company in the United States that also sells like sandwiches and groceries, like mini convenience marts. And they were hacked at a point of sale terminal. where if you're a customer there, do you really want to go there and swipe your credit card knowing that they might not be protecting your financial information? So I think the trust from both an internal perspective with employees and an external perspective from consumers and the reputational harm are significant factors. And to your point, that's also a major reason why companies don't want to take these cases to a jury.
Yeah.
That's why a lot of these are settling for big amounts. But could you imagine, John, if these cases went to a jury, would that $350 million for Google, would the jury be as forgiving, let them off the hook for that much? Or would the jury say, you know what, we're going to make this $1 billion verdict? So it could even be worse based on the factors you allude to, the emotional aggravation from the public, as well as the internal, confrontation from their employees.
Yeah, and the trust thing is, it's an issue for, a small service station grocery chain. But if you're a business like, and this is a publicly known hack, if you're a business like Ashley Madison, where they specialize in extramarital affairs, and your database gets hacked, and all of a sudden your details are in the hands of someone who's got nefarious intent, that's a pretty big problem from a trust point of view. That's surely curtains for that business.
Absolutely. There's a lot of businesses that have, I think, every business has a duty, to protect proprietary information. I feel like every company has an ethical duty to confidentiality to their consumers, right? If their consumers are paying for something, if I go in and buy a product down the street, I'm hoping that my information of what I bought and my personal information is not being disclosed to third parties. Now, we know that's not always true, and a lot of times for advertising or marketing purposes it is, but certain businesses, such as perhaps law firms where you have client secrets, right?
Yeah.
Or where the Ashley Madison example you gave, or medical information. I've read a lot of reports that PHI on the dark web is going for twice as much as PII, which is why I don't have hard data to support this, but I keep seeing more and more hacks and attempted hacks and demands in the healthcare industry. It seems like that's the flavor of the month, so to speak, in the United States.
Sorry, I was just going to say, can you explain those two acronyms for people who may not be familiar with them?
Yeah, so PII is like personally identifiable information. For instance, like your name, your address, information about you that's more surface level. PHI is your health information, so you'll be looking at information. For instance, if you're a hospital patient, you have a medical condition, and it's interesting to wonder what are the dark web actors going to do with that information. But what they're ultimately doing is if they can create a profile about you, they know who you are, where you live, what your social is, what your driver's license is, and now they add your medical information. They're creating more and more complete profiles for you that ultimately, not to get too far down the road, but what if we get into a state where there's deep fakes, right? And where there's using AI and leveraging other technologies where they can create online profiles for people knowing everything about you. That creates a serious risk for theft and for personal harm.
Yeah, and I suppose from a ransomware perspective, people are probably more likely to encourage the company that they're working with to pay a ransom if it's things about medical conditions that I may not want in the public domain, as opposed to just my personal information.
Yeah, and it's interesting too because there's not always clear data on whether or not companies are telling employees if they pay those.
Yeah.
You hear sometimes about companies settling the cases, and that's one thing if you're settling the lawsuit. But a lot of times, these types of demands are made from bad actors, and they want cryptocurrency wired or transferred to some faraway region or sent to somewhere that you don't know where it's going. And employees are wondering often, what is the company gonna do about this? Are they gonna pay off these people? And then even if they do pay them off, you'd be wondering, what's going to stop them from disclosing my PII or PHI or any other information, even if my employer or my company where I spend my money with, if they do pay them off, couldn't they still use my bad info anyway?
Yeah.
So there's a lot of risk there, and that's kind of the open-ended nature, or Pandora's box nature of this industry.
It seems one of the biggest challenges from a legal point of view, though, is often in any sort of crisis communications or crisis situation like a data breach, there's certain steps that need to be followed where you've got to come out, you've got to make the public aware of what's happened. If you do the right thing,
right,
you need to accept responsibility for what's happened, and then you need to talk about what you're going to do differently. But traditionally, from a legal point of view, most law firms would be advising the company, no, you can't take responsibility for what's happened. But if you want to minimize the impact in a court or a class action environment, do you need to take responsibility for what's happened?
That's a great question. I know we touched about this last time, and it's a fine line between you don't want to admit liability, but you also need to follow the law about disclosure requirements.
Yep.
And I think there's a third wrench I'd throw into that, which is, like you said, transparency, trying to do the right thing. I think the norm right now is in the United States and probably a lot of jurisdictions internationally, you submit the notice of the breach and you have a duty to inform the people who may have been compromised, right? What was compromised, and it's kind of the who, what, where, when, why, and showing them that you're doing everything to figure out, what happened, what's going to happen with their information. And I think the real rub would be being accountable. And not necessarily, there's a difference between admitting liability, but just saying, look, we understand this happened. We're on top of it. We're, whether or not, the company's not going to come out and say they did something wrong or we didn't have enough safeguards in place. You're not going to hear organizations do that. But accountability, I mean, from a perspective of, are you going to hire, a third-party consulting firm, a law firm to immediately, are you going to spend resources to fix what might have happened, whether it was your fault or not?
Yeah. So now that you've had the opportunity to give the presentation and we can divulge a bit more of what you spoke about, what are the sort of 4 or 5 key takeaways that you left people in the session with around, here's what you need to be doing or thinking about in order to protect your organization moving forward?
Yeah, absolutely. So I think the first one, going back to the task force, I won't rehash that, but I think it's imperative that these conversations need to be had, and there needs to be some kind of, symbiotic relationship between the different departments in an organization beyond just the task force. This needs to be something that's taken seriously by people at all levels, the C-suite down to the employees. Training. Again, are you in training people? Are you training them in person? Is the training going to be something that's where they're watching a video on the computer and it just plays for an hour and they're really doing their work on their other monitor? Or is it training that's interactive where they have to click through prompts that might be more aggravating to the employee who was trying to multitask, but it's better for the organization in preventing the breach? Also, are the trainings accounting for new types of breaches? As you may know, right, the types of breaches change, the actors change, the phishing attacks, they're getting good. And then also implementing heightened security measures. Just changing your password every 6 months isn't enough. Sure, it's a good thing to do. We still recommend it. We still do it. But, 2-factor authentication, have you considered 3-factor if you're, handling proprietary information, the financial information, medical information, and the like? These are all things I think organizations can do. I think organizations need to continually educate themselves, the continuing learning process about what other mechanisms are out there. Coming to events like the Asian Security Exhibition and Conference are important. Learning about different mechanisms or other ways you can protect your business, staying abreast of the developments in both not just the law but the technology. These are all things that companies can do on the front end to prevent. Now, to answer your question on the back end, in terms of litigation, what happens if you've been, sued in a data breach class action lawsuit? One of the things I think nowadays that we need to be cognizant of is most people have probably had their information compromised.
Yep.
Whether it's T-Mobile, Yahoo, Chase, American Airlines, all these major companies, great companies, unfortunately have had breaches, right? And chances are most people that file a data breach class action lawsuit have either flown one of those airlines or stayed in one of those hotels or gone to one of those petrol stations or gone to one of those food marts. And if they have and they've been part of a breach, one of the things I do to attack those cases up front is say, how do you know that your damage was caused by my client's breach?
Yeah.
If you've been breached 6, 7, 8, 10 times, before I got on my plane here, John, apparently all Social Security numbers were breached in the United States.
Wow.
So you're dealing with people being breached 10 times over. How are you going to prove this one breach caused you to receive the 10, spam phone calls or someone trying to hack into your credit card or create a money transfer app in your name? And I think causation to damages is these defenses, they're getting harder and harder for the plaintiffs to prove. So on the back end, I think it's important when you're defending these cases to do the research on the named plaintiff, see if they may have been part of another data breach or class action if there's publicly available information. And if not, you find that out in their deposition. And then that's a great way to try to, minimize the potential claims of the named plaintiff.
Yeah. Okay. Do organizations, I know we've touched on this briefly in the past, but should organizations be seriously thinking about what data they do and don't need to keep? Because we see more and more everyone just warehouses everything, and then they get breached, and all of this data ends up in someone's hands, and it's like, well, did you really need to keep X or Y?
I'm so glad you asked that, because I think one of the biggest ways to increase risk or increase potential exposure is by keeping more data than you need to. Retention is such a huge issue in this space, and I think though too many organizations probably have too broad of a retention, or they don't purge stuff that they don't need to. In employment law, it's different. In the States, for example, in the U.S., certain employment records you're required by law, usually under wage and hour laws, to keep them for a certain number of years after the employee leaves the organization. But what there should be is, once that anniversary hits, let's say it's a state with a 3-year retention policy, you should be deleting their information after 3 years and 1 minute, because if you don't have an obligation to keep it, why are you? And that way, if you are breached, you're not getting 5 years worth of employees swept in there, but rather just where it is. So I think coming up with retention policies in as strict and narrow as possible ways to purge without having to, staying within the confines of the law, but not holding on to data. In the consumer context, why do you need a customer's credit card information from 10 years ago? What good is that going to do if that's still on your server somewhere? Sure, it's nice to be able to store payment options, so somebody, if they change their mind 10 years later and want to come buy a product from you, it's on there, but chances are their card is expired, or maybe they're not doing business with you anymore. So I think coming up with narrow approaches, that's a great point, because if you do get breached, you're minimizing the number of people that'll be impacted.
Yeah. Well, Alex, if people want to know more about you, the company, and how to get in contact with you, where do they go?
Absolutely. My name is Alex Karazik. I'm a partner at the Duane Morris Law Firm. We're based in Chicago, Illinois, but we have offices around the world. My email is awkarasik at duanemorris.com. That's DUANEMORRIS.com. They can also check LinkedIn. Just type in Alex Karasik, Karasik, and you'll see partner at Duane Morris, and I'm on there. And other than that, I look forward to hearing from any of our listeners about any questions they may have. I'd love to chat about data breach class action litigation anytime.
Alex, thank you very much for your time, and we look forward to chatting to you again in the future.
Well, thank you, John. I appreciate the honor to be on your podcast, and I look forward to talking with you again soon.
Thank you.
Take care.